Okay, well, it's after 10 o'clock, so we will go ahead and get started. And just again, good morning to everybody, and welcome to Montgomery McCracken's webinar, Business as Usual, Tips and Advice for Employers as COVID-19 Lockdowns Are Lifted. Thank you for joining us this morning. We are excited to have three highly experienced labor and employment attorneys walk us through some of the complicated situations that they anticipate employers will begin to face as states begin to lift stay-at-home restrictions and permit workplaces to reopen. Bill Kennedy, Renee Smith, and Erin Clark regularly counsel clients on a wide variety of workplace issues, including employee hiring, performance management, reductions in force, policy creation, labor issues, and drafting various employment agreements. They each also represent clients in federal and state court, as well as before administrative agencies on matters that involve harassment, discrimination, retaliation, whistleblower, wage and hour, breach of contract, and wrongful termination claims. Thank you, Bill, Renee, and Erin, for joining us this morning. We want our listeners to leave this webinar with practical advice, and so we will be discussing 6 scenarios that bring up a variety of questions and issues that employers will need to know how to walk through as they bring employees back to the workplace. This first slide summarizes high-level key takeaways, which we will break down in more detail throughout the presentation. Our first 4 scenarios will focus on employee issues, and in the last 2 scenarios, we'll focus on worksite safety. Our panelists will be identifying some potential areas of new liability that we anticipate will be developing due to the current pandemic. Every state is at a different phase in terms of their reopening plan, and most of the Northeast, as well as the West Coast, are largely under shutdown orders. It's important to note the most specific guidance is coming from the state level, and in some states, there's even specific reopening requirements varying by industry. Today, we will comment on some trends we are seeing from state and federal guidance, but it's critical that every employer is closely watching every state in which they do business, as this guidance is rapidly changing, definitely weekly, and sometimes even daily. We anticipate that our speakers will be sharing information for about 45 or 50 minutes, and we hope to have at least 10 to 15 minutes at the end of the presentation to answer your questions. There's a private chat feature on the right-hand side of your screen, and we encourage you to submit questions throughout the presentation through that chat window. Please know that all of your questions will only go to the speakers, and there will not be any public sharing of names or questions. We will address questions at the end, and we'll try to address as many as we can. Without further ado, we'll jump right into our first scenario. In this scenario, the employer's 75 employees have been largely working remotely for the past 8 weeks. The governor, however, has recently determined that this employer may reopen the physical work locations. The employer would like to get back to business as usual as soon as possible. So for this first scenario, I'm going to go to Erin and ask Erin, can the employer require all of their employees to report back to their office or to their workplace on the date of the reopening?
Thanks, Kelly. So first, whether an employer can bring everyone back all at once, that is going to largely depend on the state where the workplace is located. We're seeing states that are reopening doing so on a gradual basis. And even in states where restrictions have been lifted or are starting to lift, for example, in Pennsylvania, 24 counties today are entering the second phase of reopening, the yellow phase. But even in those counties, if an employee can telework, the employer must require the employee to continue to telework. But now, setting that aside, if there's no statewide order, if you have the discretion, or if you're planning when you will have the discretion to bring everybody back at once, we're still recommending, and many employers are still doing so on a gradual basis. And how they do that will depend on the workplace, the location of the office, and the needs of the business. So some employers are bringing people back gradually, only as is necessary for the employees to be in the office. Other employers are doing so in teams. So one team works 1 week and then another team works another week. Or some employers are even asking for volunteers to return to the workplace. Not everybody is enjoying working at home. Some people are very eager to get back into the workplace, but doing so in phases will enable the employer to follow all state and federal guidelines for social distancing. And it allows the employer to make adjustments as necessary if a circumstance arises that they had not previously anticipated. Of course, you need to also think about your business, where you are. If you're in an area where there's significant community spread, you may want to have employees continue to work from home, and you also want to consider your workforce. So if you have employees who travel a lot, you may want to more slowly bring those employees back to work. Now, one issue that will come up, of course, since everybody who's been working in this scenario has been teleworking, is employees may want to continue working at home. It's been going well for some people. They'd like to continue doing so. Now, once restrictions are lifted, there is no legal requirement that would require an employer to continue allowing telework. There may be a number of reasons why it would be advisable. So for employee morale, to retain employees who to retain employees who you've trained and you want to continue working for you. You may consider that. Some of my colleagues on the next couple of slides will be discussing other reasons why employees want to continue working home. But one important reason that you should consider and you should be very mindful of is if the reason the employee is asking to work from home is because of his or her health condition. That may trigger your duties under the Americans with Disabilities Act to provide a reasonable accommodation for that employee. For example, if you have an employee who comes to you and they have a heart condition, and that's a condition that makes them susceptible to serious illness from COVID-19, in that circumstance, you must engage in the interactive process. Now, of course, the first part of that analysis is whether attendance in the workplace is actually an essential function of that job. If the request is temporary, only while this pandemic continues, that may undermine your argument that attendance is an essential element of that job. Because if things have been working out fine, you may have to continue that. But you also then need to engage in the interactive process. As with all requests for accommodations, you don't have to automatically grant whatever request the employee is making simply because the employee is disabled. So you should explore other avenues for protecting this employee. And that may be moving the employee's workspace. It may be providing the employee extra equipment. Or in the end, it may be teleworking, but those are all factors that you must consider in deciding whether to permanently or temporarily allow an employee to continue working remotely.
Thanks, Erin. And so when an employer is bringing back employees, will the employer have to consider how their employees are commuting and how they're getting to work when that work location opens?
Right, and they may have to. Of course, if the employee who we were just discussing, if the concern is not the actual physical workplace, but it's that the employee has to ride the train, and if they ride the train, there's a higher chance that they'll be exposed to COVID-19. Allowing that employee to telework may be a reasonable accommodation. But you should also consider whether you want to encourage ride sharing, so Uber, Lyft, or taxis. And if you do that, whether you'll reimburse employees for those expenses. You'll also should consider if somebody absolutely must be in the office, whether you want to pay for their mileage or pay for their parking fees. These are all things that you need to take into consideration for employees who use public transportation. But also, on that point, you should also carefully review your insurance policies to make sure that you're not incurring any liability for encouraging or requiring such means of commuting.
Great, thanks, Erin. So that brings us to our second scenario. And in this scenario, the employer has furloughed 100 employees for the last 8 weeks. But now that employer is permitted to reopen their work locations. Due to economic uncertainty, however, the employer intends to first recall a small team of managerial employees to take on responsibility for the performance of all work within the work site. The employer plans to reward these managers with bonus pay or compensatory time. So that's what I'm going to ask Bill. What should the employer be considering before making such decisions?
So, as in contrast to scenario number one, which dealt with moving employees from remote work to moving employees from furlough back to active work, so presumably from unemployment back to employment. This question really raises two big issues. One is, you can stay on this slide. One is not recalling everyone. We're only recalling a small group of employees, and how you make those decisions, and employers ensuring that they're basing those decisions on business reasons or safety reasons. And the second big issue is we're calling a small group of managers who are going to do the work of every employee. So that gives rise to FLSA concerns, and I'll talk about those in a minute or so. Erin mentioned the idea of doing a soft return, and a lot of businesses are going to want to consider doing a soft return to the office. In other words, not having every employee who can return to the office on day one, and especially not everyone who can returning at 9 a.m. on day one. That really defeats the purpose of the social distancing rules, and it would not really be in compliance with any of the state's social distancing and shutdown orders, even when those orders begin to be lifted. Regardless of whether the employer's decision to return a small group of employees based on a business reason or a safety reason, the decisions on who returns and when should be based on business justifications. Whether there's a department or service that's likely to begin first, or whether specific customers are likely to need services first. One of the reasons for being very careful about those decisions is avoiding discrimination claims. So if the employer furloughed employees in stages, you might consider recalling employees in stages based on the same criteria. And ideally, those would be well-articulated criteria that are based on business justifications. There are general discrimination claims you want to avoid. So for instance, discrimination claims that you selected one employee over another based on race or gender or religion. But then there are also specific discrimination claims that could be related to recall decisions. And in fact, we mentioned that the guidance on these issues is evolving on a daily basis. Just yesterday, the Equal Employment Opportunity Commission updated its guidance to warn employers against making assumptions about which employees will return, which employees should return, and whether or not an employee will be productive after returning based on an underlying condition. So we've all seen the guidance, and we all may be concerned about people we know who have underlying conditions that put them at risk for contracting coronavirus or contracting a serious case of coronavirus. The EEOC really warns employers against making assumptions about the employee's willingness to return to work or ability to perform just based on the employer's knowledge of an underlying condition. And what the EEOC says is treat this like you would any other direct threat situation. A direct threat is a very high bar set by the EEOC. The employee should only be barred from the workplace if the employee's health creates a direct threat to that employee or other employees. What this all boils down to, though, is engaging in an interactive process. Just have a conversation with the employee. You don't have to make an assumption, but you can tee up with an employee that you're taking certain precautions, that you're taking those precautions in compliance with government orders, but also in an effort to keep employees safe and prevent the spread of disease in the workplace. And you can have a conversation with one or have a conversation with all of the employees. All the things we're going to talk about in this presentation are being done at least in part for the benefit of your employees and customers to prevent the spread of disease. So while we're talking about legal compliance, you should tell your employees everything that you're doing to keep them safe. With respect to recall decisions, think about the messaging regarding the reasons for the furlough and the expectation of recall. If in March or early April, when the employer furloughed employees, the employer gave employees either verbally or in writing an expectation that they would be recalled when the orders were lifted, and circumstances have changed, that's okay. But the employer should be clear with employees that circumstances have changed, and be clear with employees about the criteria or the reasons for recall decisions. And make sure as the employer that you're documenting those reasons to support the recall decisions, and that those decisions are based on legitimate business circumstances. Maybe there's one organizational unit, one department, one client that is either going away or is going to be much slower to reopen. Just let employees know that. You don't want to keep people hanging around with an expectation that they're going to be recalled. That's only going to lead to, it's only going to impact morale, lead to confusion among employees, and encourage employees to believe that they're not being treated fairly. If you're a unionized workplace, you've got to make sure you're complying with the collective bargaining agreement with respect to recall decisions. And if outside the union context, make sure that you're complying with any policies the employer has related to leaves of absence and recall of employees. I touched on the aspect of Fair Labor Standards Act compliance, but there's really FLSA and state law wage and hour compliance. If you're calling exempt employees back to work, and though a small group of employees is now going to perform all of the work of all the employees in the workplace, consider whether those employees are still performing exempt duties. First of all, they may not be supervising anybody. So if their exemption was based on the fact that they were supervising people and they will not be supervising anyone, they may not qualify for an exemption. And even if it's in the short term, the employer, it may be prudent to reclassify those employees as non-exempt. If it's just a strict duties based without supervision, so these are exempt administrative employees, but they're going to be performing a broad range of duties. Consider how short-term that arrangement will be, and if it's expected to be even a month or so, you might want to convert the employee to an hourly basis, just for the period until you get back up and running and have the other employees back in place. With respect to state laws, consider whether there are notice requirements that you have to comply with. If you're giving employees hours bonuses or comp time as a reward for being a small group who's returning early, you may not have to give specific notice. But if you're reducing employees' pay, in almost every state you have to give notice. In many states you have to give specific written notice, and in some states you even have to give a specific period of notice prior to reducing an employee's pay. With respect to hours bonuses too, for exempt employees, make sure that what you're doing is not going to jeopardize their exemption. So you don't want to start treating an exempt employee like an hourly employee. So if you have exempt employees, you want to reward them for returning early or for chipping in significantly during the shutdown or during the recall. Think about whether you can give some sort of a bonus that isn't tied directly to hours. And the last point on this slide is documentation. As I mentioned earlier, you want to document the reasons for your recall decisions, and to the extent you're treating employees differently than one another. With respect to recall, you want to document that those decisions are based on business considerations.
Thanks, Bill. So this then goes into our third scenario, in which we have employees who are receiving notice that their employer's worksite is reopening. And several of these employees notify their manager that they do not feel safe returning to work or to the work site. So for this one, I want to ask Renee. Renee, in this situation, what should the manager do?
Thanks, Kelly. The answer to that question may depend on whether the employee is refusing to come back to work after being furloughed or is refusing to return from remote work. The bottom line is that employers should try to ascertain the reason the employee does not feel safe returning to work and see if there is a way to reasonably address the concern. For example, if the employee is already working from home, is continued telework an option? For a furloughed employee, should you consider leave as a form of accommodation? When these questions come up, and they will, I caution employers against an outright dismissal of employee concerns, especially if that employee falls within a vulnerable population or is suffering from mental or emotional distress related to COVID-19. In essence, in the current climate, accommodation requests will likely be more prevalent for several reasons. Employees are anxious or nervous about returning to the office. Employees are fearful of contracting COVID-19 in the office and passing it to others at home, or employees are concerned that the office environment will trigger pre-existing mental disabilities. With respect to these and other requests for an accommodation that may arise in this new environment, it's a good idea for managers to be reminded that there are no magic words to trigger the employer's obligation to explore the need for reasonable accommodation through the interactive process, and that EEOC guidance gives an employer the opportunity to ask questions and engage in the interactive process to determine if a reasonable accommodation, even if that accommodation is only on a temporary basis, is necessary. In a situation where an employee with a known pre-existing medical condition is refusing to return to work, the employer can ask questions to determine if the employee is disabled, to discuss how a requested accommodation would enable the employer to perform his or her job, to discuss alternative accommodations, and to request medical documentation if needed. So staying on this slide, Kelly, what steps should an employer take when an employee is resistant to returning to work? There are a few things that should be considered. The employer should consider whether further exploration of the reason for the refusal to return to work is warranted. Consider whether the employee's health status is the reason for the employee's refusal. Is the employee a qualified individual with a disability? If so, the employer should engage in the interactive process. Determine if the employee is eligible for leave under the Family First Coronavirus Response Act. Remember that generally employees are not entitled to leave under the FFCRA simply due to a fear of exposure to COVID-19. However, in certain situations, an employer may want to consider offering other forms of leave as an accommodation. Ascertain whether the employee is requesting leave or remote work environment, or is that employee simply refusing to return to work. So given the likelihood that some employees will not feel comfortable returning to the office, what are some of the things that employers should be thinking about as you plan to reopen? Hopefully most employers are thinking about getting ahead of potential issues that might arise by preparing for them in advance. First, employers should train both the management team and HR to ensure they are aware of available FFCRA benefits. Second, employers should remind both the management team and HR team that the interactive process framework has not changed, even if the results have changed. Make sure managers and supervisors know to send employees to HR for accommodation requests. Consider placing an end date on accommodations or approving certain accommodations on a temporary basis just to get the ball rolling. And most importantly, stay in communication with employees who requested accommodations pre-COVID and during COVID to get those requests resolved proactively. Next slide. An employee who simply refuses to return to work may face consequences such as termination or ineligibility for unemployment compensation. If we go back to the previous hypothetical and assume that a furloughed employee is collecting unemployment, that furloughed employee may be reluctant to return to work because he or she is receiving more money through unemployment under the CARES Act. However, current guidance suggests that barring unusual circumstances, a request that a furloughed employee return to his or her job likely constitutes an offer of suitable employment that the employee must accept. Therefore, a furloughed employee who refuses to return to work not only risks losing his job, but may also lose unemployment compensation benefits. For example, in Pennsylvania, employers are required to notify the Bureau of recall refusals within 7 days from when the offer was made. Finally, the Payroll Protection Act creates a significant incentive to bring back furloughed employees. PPP loans that are used to recall or rehire the same workers who were laid off or furloughed will be forgiven as long as they are rehired or recalled by June 30th with at least 75% of their previous pay. The SBA guidance provides that laid-off employees whom the borrower offered to rehire are excluded from the CARE Act's loan forgiveness reduction calculation. It's therefore important for employers to document an employee's rejection of an offer of reemployment.
And just, Renee, the guidance is a little bit confusing, but that I think the long and the short of it is that if an employer offers an employee a return to work or return to the payroll and the employee refuses, that the fact that that employee has not returned to work will not count against the employer for forgiveness purposes. Is that right?
That's right. That's right.
Thanks, Renee. It's very helpful guidance. And so what sort of employment policy changes should employers be looking to make or consider?
Well, absolutely, the pandemic will likely force employers to review and update employment policies on leave, attendance, and remote work. One of the considerations that may need to be reviewed is whether regular attendance in the office is a necessary or essential job function. If you're a covered employer, you should know and ensure compliance with the FFCRA. The non-enforcement period ended on April 17th, and the Department of Labor is now beginning to enforce these policies against employers who fail to comply. Employers should also educate employees on tactics for preventing COVID-19, make sure employees are aware of the signs and symptoms of COVID-19 and the recommended actions for preventing the spread of the virus. In short, employers should repeatedly, creatively, and aggressively encourage employees and others to avoid exposure. The messages that employers should be given to your employees, as recommended by both the CDC and various state departments of health, include those that we've heard for weeks: washing hands frequently and using hand sanitizer, avoid touching your eyes, nose, and mouth, avoid close contact with others, and refrain from shaking hands for the time being, covering your cough or sneeze with a tissue, cleaning and disinfecting frequently touched objects and surfaces, wearing masks, and perhaps most importantly, staying home when you're sick. Some states, including the Pennsylvania Department of Health, require that flyers including this information be posted on the premises. Next slide. So during this unprecedented time, employers and employees should remain aware that existing employment laws still apply. Employees are still protected against discrimination, harassment, and related misconduct in the workplace, even if they are not working at a conventional office. An employer simply can't tolerate discrimination or harassment for any reason, including harassment or discrimination based on COVID-19. It's therefore essential that employers remind employees of their policies against discrimination and communicate to employees that fear of COVID-19 should not be misdirected against coworkers, vendors, or customers. Even with these warnings, however, certain types of discrimination and harassment will likely increase. For example, employers will need to closely monitor any concerns that employees of Asian descent in particular are being subjected to disparate treatment or harassed in the workplace because of their national origin. Employers may also see a rise in coronavirus-related lawsuits from vulnerable employees claiming they were not hired or were terminated because of fears of increased absenteeism or an inability to work. From employees who have recovered from COVID-19 and are back in the office, or even from parents who need to care for themselves or their children who are out of school and they have taken FFCRA leave. So what should you do if an employee or client refuses to work with an employee who has been diagnosed with and recovered from coronavirus? In addition to reiterating your policies against harassment and discrimination, the employer should remind that individual that it has taken every precaution state and local governments have advised them to take, and that this employee would not be in the office if it was not safe for him or her to be there. Next slide.
Thanks, Renee. So now continuing with the idea of the new challenges surrounding the FFCRA leave. In this fourth scenario, we have an employer who does have several employees out on FFCRA leave because schools are closed or childcare is unavailable. But now with government restrictions being modified, this employer can reopen their office on May 11th, and the employer thinks that their employees' childcare providers should also be available by that time. So in this situation, Renee, I'll go back to you on this question. Can the employer order employees on leave to return to the office if they don't have childcare?
Thanks again, Kelly. An employer should absolutely not assume that just because the workplace has reopened, childcare options have also reopened. Any covered employer, that is an employer with less than 500 employees, that reopens and brings workers back from furlough or hires new employees will have to contend with the FFCRA through December 31st of this year. In the situation presented in the hypothetical, the employee may be eligible for leave under the FFCRA if schools and even summer camps are closed and alternative childcare is not available. I want to mention an important distinction as we approach the summer months, and that is that the FFCRA applies only to the situations where school is closed because of COVID-19 and not because the school or childcare provider is closed for summer vacation or any other reason that is not related to COVID-19. In addition, keep in mind that some state and local laws may provide an employee with mandated leave in the event of a public health emergency, such as the coronavirus pandemic. As most of you already know, on March 18, President Trump signed into law the Families First Coronavirus Response Act, requiring applicable employers to provide paid sick leave to employees and significantly expanding the Family Medical and Leave Act. The act applies to employers with 500 or fewer employees and provides employers with refundable tax credits for payments up to the stated daily caps and maximum. Employers should remember that there are notice requirements under the act. Many employers sent the required notice of FCAR requirements to employees by mail since their offices had already closed at the time the act became law. But as we return to our offices, it's important to make sure the notice is posted in a conspicuous location in the workplace. Focusing on this slide here, although most of you are already familiar with the FFCRA, I wanted to take a few minutes to cover a few key provisions of the act. There are two primary benefits under the Act, the Emergency Family and Medical Leave Expansion Act and the Emergency Paid Sick Leave, or EPSL. The Emergency Family and Medical Leave Expansion Act provides job-protected leave for employees who are unable to work or telework due to a need for leave to care for a child under the age of 18 if the son or daughter's school or place of child care has been closed or the child care provider is unavailable due to a public health emergency. To qualify, the employee must have been employed for at least 30 calendar days. The first 10 days of the leave is unpaid unless the employee elects to substitute EPSL or the employer allows the use of accrued paid time off. After the first 10 days, eligible employees are entitled to 2/3 of their regular pay, capped at $200 per day and $12,000 total. The second benefit under the Act, Emergency Paid Sick Leave, provides full-time employees with 80 hours of leave if the employee is unable to work or telework for any of the following reasons: to comply with a federal, state, or local quarantine order related to COVID-19, if the employee has been advised by a healthcare provider to self-quarantine, if the employee has symptoms of COVID-19 and is seeking a medical diagnosis, if the employee is caring for an individual who is subject to a quarantine or who has been advised to self-quarantine, if the employee is caring for a child or the child's school has been closed and child care is not available, or if the employee is experiencing any other substantially similar condition as specified by the Secretary of Health and Human Services. Unlike the prior benefit, EPSL is available for immediate use by all employees regardless of how long that employee has worked for the employer. EPSL is to be paid at the employee's full rate of pay, subject to a cap of $511 per day and $5,110 total for the first enumerated reasons, all of which are listed on this slide, the first three enumerated reasons. Paid sick leave for the remaining qualifying reasons is limited to 2/3 pay up to $200 daily and a $2,000 cap. For those of you with a part-time workforce, you should know that part-time employees are not excluded and may receive a reduced entitlement under the Act. One thing I'll mention is that it's important to remember that FFCRA leave is not available to an employee under the Act if the employer closed its work site and has no work, or if the employee was furloughed. One final note on the FFCRA is that employers should stay abreast of the Department of Labor Resources, including its frequently asked questions section, because information on the Act is updated and changing frequently. Next slide. I'll close by spending a few minutes talking about how an employer can prevent the abuse of leave policies in this COVID-19 era. An employer can discipline an employee who unlawfully takes leave under the FFCRA based on misrepresentations, including, for example, to care for the employee's children when the employee, in fact, has no children and is not taking care of a child. Employers can also continue to enforce their attendance policy, but must ensure that they are treating all employees consistently. Employees should consider the context of these types of policy violations because technical enforcement of attendance during COVID is difficult to justify. Prior to COVID-19 office closures, many employers had already begun to offer unlimited vacation or sick leave policies, which provided employees with the discretion to decide when and how much leave to take. Under these policies, employees were permitted to take as much paid time off as they desired, as long as they met the requirements of their position. Now, employers must consider whether employees who abuse these policies will be disciplined. If you choose to terminate, you may be defending your actions against a person who will likely be viewed as a sympathetic plaintiff. Also, you should consider how you will prove that an employee is not sick or that he or she otherwise abused leave. You'll need to have concrete evidence if you're going to discipline or terminate an employee on this basis. Finally, if you opt to implement a voluntary attendance policy as you move toward reopening your physical offices, make sure the at-will employment relationship is maintained and avoid any written guarantees against termination if an employee does in fact use that policy.
Just, if I can jump in before we leave this slide, I want to reiterate something Renee touched on, and that is this hypo started with it started with employees returning to the workplace and requesting leave, or employees having been on leave to care for children who are either in school or whose child care is not available. And a couple things that I've actually heard specifically in the last couple weeks related to those issues are number one, an employer should not assume that modification of the business closure rule. So in other words, because the employer is allowed to reopen its office, that automatically means that an employee's childcare is now available. It sounds like it's more likely that childcare will be available once the business closure rule is modified, but you need to confirm that with employees. The second is, Renee mentioned that when schools close for summer, that doesn't qualify. That's not a qualifying reason for FFCRA leave because closing for the summer is not related to COVID-19, but the DOL just yesterday issued additional guidance that said that even though school closure for the summer vacation is not an FFCRA reason for leave, an employee still may be eligible if a camp or other place that they would normally send their child is not open because of COVID-19. So just something to keep in mind.
Thanks, Bill.
So moving on then to our next scenario, we're going to switch gears a little bit from issues with bringing employees back to your work locations and start to focus on the physical workplace and some considerations for employers about what they should be doing to protect employee health and safety at work. And so in this scenario, the employer had gone to a skeleton crew staffing model since mid-March and has only had 2 or 3 of its usual 200 employees reporting to the office on a regular basis. All of the other employees in this scenario have been working remotely. The employer would now like to implement required precautions when workers begin to report to that location again. And so I'm going to ask Erin, what changes to the physical office should the employer be considering?
Thanks, Kelly. So when you're preparing to reopen your office, something to keep in mind is that, look, the office is going to look very different than it looked just a few months ago. You'll have to be thinking about changes that we hadn't anticipated. It's what everyone is calling the new normal. But at a minimum, you must take certain precautions. So you must ensure that employees can socially distance when they're in the workplace. That is, be at least 6 feet apart. This may require you to reconfigure workspaces, particularly if employees work in cubicles and work within 6 feet of each other. You'll also want to look at common areas of break rooms. We've seen employers who are considering removing chairs from break rooms to prevent employees from congregating in the break rooms. You also may need to install physical barriers between employees, so screen guards or plexiglass, just to ensure that the employees are not sharing germs, right? Limit the number of employees in high traffic areas or on elevators. And as much as you can, you really should be limiting the sharing of equipment. So if there are employees who use the same phones or the same desks, you want to limit that as much as you can. So you'll also need to evaluate your cleaning procedures. Right now, according to the CDC, if the office has been completely closed for at least 7 days and there's been no access to the office, you just need to do a regular cleaning before reopening. But to appease your employees, you may want to do more than that. You also should follow the CDC's guidance to ensure that you're using the right materials to clean and that you're cleaning often enough, and making sure that high touch areas you modify if you can. So for example, for doors, you may want to adjust the door handles so employees don't have to touch them to open them if you can, or even if security will allow it, you leave the doors open so employees don't have to touch those when they reopen. And keep in mind that when you're reopening, what you have to do, what you must do, is generally going to be guided by the state. So in Pennsylvania, for example, the Secretary of Health has certain requirements for employers who are operating or entering the yellow phase. So that includes requiring non-medical masks in the worksite, providing employees with soap, hand sanitizer, and disinfectant wipes, and ensure that common areas, high touch areas, are cleaned on a regular basis. Now, keep in mind, this guidance is evolving as we learn more about the virus and how it's transmitted and what measures are adequate to protect employees. And the perfect example of that is masks. In March, we were all hearing that a mask is not required. Now, a mask is required. And as you'll see, Pennsylvania has even ordered that employees wear masks in the work site. Okay, next slide.
So when employers are looking to secure their workplace, does that include monitoring employee health? And should employers be looking at monitoring employee health?
Yes, and I think we actually had an audience question on this issue. So whether you should screen employees, that will depend on a number of factors, including the state law that you're operating under. It may require you to take certain steps. Now, you need to be careful when doing so. Ordinarily, you can only conduct a medical exam, so screening an employee for symptoms or taking an employee's temperature, if it's job related and consistent with business necessity. But the EEOC has given guidance that during the pandemic, so right now as things are evolving, an employer can ask employees about symptoms of COVID-19. In addition, more recently, the EEOC has issued guidance that employers can test employees for COVID-19 before they enter the work site, and they can also measure an employee's body temperature. Now, we had a question on what the best way to do that is, and there are 3 options that you can use. So you can have a third party do it. You can pay someone to come in and just take employees' temperatures. Practically speaking, though, that may be very difficult. It may be cost prohibitive. And also, there may not be enough medical professionals to come into a workplace to take employees' temperatures. So you should also consider whether you have an employee on site who can take employees' temperatures. And if you do, you want to train that employee. You should think about who it will be. Probably, I would advise using somebody in human resources as opposed to someone who just has available time to take employee temperatures. You want to ensure that the employee is properly trained, has the right equipment, so they have protective gear to make sure that they don't get the illness. And you want to provide a private area for the temperature measurements. so that other people cannot see, because remember, that's a medical exam. So it has to be kept confidential, the employee's temperature, and it has to, if you're going to maintain it, it has to be kept in a separate file, separate from the personnel file. The other question that often comes up and is coming up with this issue is whether you need to pay employees, so non-exempt employees who are waiting in line, in order to have their temperature paid. And this is a complicated question, and unfortunately at this time, this is a novel issue, so we don't have case law or official guidance telling us whether we have to pay or not. At this time, the more cautious approach is to pay employees, and if you cannot do that, if you're not willing to do that, that's something that you should carefully look at under the governing laws, and you should consult counsel if possible. Okay, next slide.
Thanks, Erin. So it does sound like employers can monitor symptoms the way you just described. And so what should an employer do then when they receive notice of a positive COVID-19 test? What do they have to do?
Right. So the first thing an employer must do is, if somebody is exhibiting symptoms of COVID-19, or if we learn that there's a positive diagnosis, the employee must be sent home. They may not be allowed in the workplace. And what to think about right now is how you're going to handle those situations. So whether that leave is paid or unpaid, whether it's covered under any applicable laws. You'll also need to figure out how you're going to notify coworkers. So particularly in Pennsylvania, you need to engage in contact tracing. So you'll have to figure out how you're going to learn who that employee has been in contact with. And when you notify the coworkers, remember that it still must be confidential. So you cannot identify the employee who is COVID-19 positive. And you'll also need to think about returning to work and whether you're going to require a doctor's note. In general, you can follow the CDC guidance on when an employee can return to work, but you can also require a doctor's note. At this time, of course, doctors are incredibly busy, so you may want to think about other means of an employee certifying returning to work. Okay, next slide. So another issue that's going to come up for a lot of employers is travel. In general, right now, the recommendation still is for non-essential business travel that employers should not do it. You should monitor CDC guidance as best as you can. And if your employee has to travel to a high-risk area, consider imposing a 14-day self-quarantine after they return, or requiring telework for that period. Of course, if the employee has to travel for business reasons, you may want to consider paying the employee, even if they're not able to work remotely during that time. As far as personal travel, though, employers cannot restrict personal travel. And this is because a number of states, including New York, New Jersey, prohibit employees from discriminating against employees because of lawful off-duty conduct. And if a person can lawfully travel to an area, an employer cannot punish them for doing so. Of course, you can take certain precautions. You can request that employees notify you of personal travel. You can require employees to require telework or be subject to a 14-day quarantine period when they return. Or you can request that employees alert you if they have symptoms of COVID-19.
Thanks, Erin. And so we are getting a lot of great questions, and we'll be answering a lot of them at the end. But one that's come up that might be best to talk about right now is just to clarify on the employee temperature screening. Is it a best practice or a requirement to use a medical professional? Either Erin or Bill, if you'd like to weigh in on that.
Sure. There's no reason that you have to use it. This is Bill, obviously. No reason you have to use a medical professional to take employees' temperatures. You might even, depending on what type of thermometer you have or temperature screening device you have, You might let employees do it themselves, just have it available for employees and say that everybody entering the facility has to take a temperature. And if you're above 104, you should leave and notify your supervisor or HR that you've got a fever and you're going home. You can have somebody from HR do it. I think the question, I want to make sure the question is may be related to temperature screenings, but it may also be related to more general health screenings. And I think employers need to be really careful giving employees basically medical examinations in the workplace that are not specific return to duty examinations. So in other words, they're not related to an employee getting injured and wanting to come back to work, and they're not being done pursuant to an employment policy. An employer really needs to be careful if you're going to conduct a full-scale medical examination of an employee. What most of the guidance recommends is not that you do a medical examination, a physical examination of employees, but that you take their temperature or have employees monitor their own temperatures, have employees monitor their own symptoms, and if an employee believes that he or she is experiencing any of the symptoms of COVID-19, the employee should go home right away. If the employee is in the office, the employee should not come to the office if the employee hasn't come in yet. And either way, the employee should notify HR or a supervisor of the symptoms, and the employer should take prescribed action depending on how close the employee's contact with other employees has been, how frequently the employee was in the office, which parts of the office the employee spent a significant amount of time in. Erin, anything else on that screening question?
No, not at this time.
And then there was another question I think that came in that was related to Erin's section, to this scenario. So this scenario dealt with the physical work site and potential changes that need to be made. And someone asked on, did I say 104 degrees? Somebody just sent a notice, it's 100.4. But the physical work site, someone asked a question about an employer who leases or rents a facility from a landlord. What should the employer do to make sure that the landlord has the facility protected? So, and theoretically, your employee could have an action against the landlord if the landlord put the employee at unreasonable risk, but you as the employer are ultimately responsible. So as the employer, you need to do everything you can to comply with the guidance and the orders. So if, for example, you're an employer that's had everyone on furlough or everybody working remotely, and you're about to come back to the physical work site, you as the employer should do what you can do, and that's having sanitizing, cleaning wipes, having hand sanitizer, having soap in the bathrooms, giving employees enough time, enough breaks that they can wash their hands regularly, having face coverings available for those employees that don't have their own, taking other actions that are required by the guidance. But with respect to the building, you as the employer need to be in contact with the landlord to make sure that the landlord has done everything the landlord's responsible for doing to keep employees safe. And in many cases, the landlord may be required to do temperature screenings before anyone enters the building, right? This is the landlord's place of business as well, depending on the type of building. If it's a building that you are leasing that you're entirely responsible for, look at the lease to see what the landlord may be responsible for. But if you're responsible for the whole structure, you may be responsible for taking all the actions that are required, like adjusting the inside of the workspace so that people aren't sitting too close together, making those sorts of sanitizing agents available. So I hope that answered the question. And Kelly, we can go to the next scenario.
Thanks, Bill. And I know we're getting close to the top of the hour, so just so our listeners know, our panelists, we have a few more minutes, so we'll finish this last scenario, and then our panelists are willing to stay on for a little more, maybe 5-10 minutes past 11, so we hope that our listeners can stay with us and we can answer the rest of the questions. So in this last scenario, the employer, in according with the governor's orders, is now requiring its employees to wear personal protective equipment, or PPE, such as a mask or gloves, in the workplace at all times. And one employee reports to their employer that he's unable to wear these items due to an allergic reaction. So for this one, I'm going to ask Bill, how should the employer respond to this report?
So this is, the way it's asked is, so for Pennsylvania employers, for example, there's a Pennsylvania order regarding essential businesses that gives advice about face coverings, and that same advice is incorporated into the yellow phase of the governor's guidance. So even when employers who have not been operating as essential all this time, when they do enter the yellow phase, you're going to have to, there's a rule that employers make it a mandatory requirement to wear masks while at the work site. And it doesn't have to be a specific type of mask. It just has to be something that's consistent with CDC and state guidelines. So it can be a cotton, a t-shirt, a bandana. So what the employer can do in this specific situation is have a conversation with the employee about what about the mask makes the employee unable to wear it, and whether there's another type of mask or another type of material that would work for the employee. And the Pennsylvania order, another important point is that it requires that employers make masks available, but it also says that the employer may approve employees' homemade masks. So it really can be any type of face covering that keeps in the employee's saliva particles and things that might enter the air when the employee is talking, coughing, sneezing. That's really what these face coverings are designed to do, keep what the wearer has in. So making this, tweaking this hypo a little bit to say that maybe it's not a medical condition, maybe it's just a refusal. Well, with respect to the medical condition too, keep in mind that if this is a disability, if the employee's allergy rises to the level of a disability, you actually are required to engage in an interactive process about how you can accommodate it. But again, a reasonable accommodation for that type of disability or that type of medical condition it's likely that finding a different type of mask or different type of material is enough of a reasonable accommodation. If the refusal to wear a mask is not related to a medical condition, if it's just a general refusal, or I don't feel like it, or I don't have to wear a mask, the employer can take disciplinary action. You as employers, whether you're already open and have been open this whole time, or you're planning to reopen, you're going to be taking a lot of steps and spending a lot of time and money trying to comply with these orders. And all these orders are aimed at trying to keep your employees safe, your customers safe, and reduce the spread of COVID-19 within the workplace. So while this presentation is about legal compliance, you should be communicating with your employees all the steps you're taking and everything you're doing to keep them safe. And one of those things is making people wear face coverings. And if there's somebody in the workplace who doesn't want to do it, that employee can be disciplined. And should be disciplined, especially in states like Pennsylvania. And I'd expect that New Jersey and New York, once they start to the reopening process, we've already got orders in those states that people wear face coverings in public. I'd imagine that when they return to work, they're going to be required to wear face coverings in the office. There's also OSHA's general duty clause, and OSHA's guidance says that they're enforcing their regulations to make sure that employers are not putting employees at risk of contracting COVID-19 in the workplace. And part of that is taking all the steps you're taking. The other part is making sure that employees are complying with the rules. With respect to EEOC guidance, if we're talking about a disability or a medical condition, if an employee says, I can't wear this mask because I have an allergic reaction, maybe there's latex in the mask the employer provided and the employee has a latex allergy. Well, the employer can make a concession. What the employer should not do is send an email to everyone that says, good morning, everyone. Pete told us today that he's allergic to latex. If anybody else has this problem, please let us know. That may seem obvious, but on the other hand, it seems like it's not such a big deal, so why not do that? Well, it's a medical condition and you shouldn't make it public. But what you can do is once this hypothetical Pete brings it to your attention that he can't wear the mask, you can send an email that says, if anybody has a problem with the mask we've provided, let us know. The guidance allows us to approve other types of masks, other types of materials. So just let us know and we can work with you. And then moving to the last slide, there may be situations where employees believe that they're complying with all the guidance and all the rules. So an employee is wearing a mask in the office, but there are a lot of other people in the office who wear masks into the office, but then kind of take them off and stuff them in their pockets when they get there. And that's really not consistent with what the guidance is. What we don't want to happen is for employees to be chastised for wearing masks, employees to be chastised for washing their hands too often, or for being germaphobes or things like that. You can imagine a whistleblower claim against a company if an employee is being chastised or being harassed for complying with government guidance. Employers also need to be conscious of the possibility of workers' comp claims, negligence claims by employees or by members of the public, customers, wrongful death claims if somebody contracts the virus and unfortunately gets very sick or passes away. Employers need to be conscious of those things. And one of the best ways to combat the possibility of a claim like that is to do what's reasonable and do what's required. And if you take those steps, we think it's going to be much less likely that an employee is going to have a successful claim against the employer. And that's the end of the presentation. I think to Kelly's point, we did get some questions, and one of the reasons we went to 11 o'clock is because we answered a number of the questions as they came in because they related to specific scenarios. I'll restate that we got a question here for me when I was talking about the temperature check. Did I mean to say 104 degrees? I did not. If I said 104, I meant 100.4. If an employee is above 100.4 or higher, the employee should go home or not come to work. And then the question is, do you have to pay employees if they're sent home? Well, if you've got sick leave policy that allows for an employee to take sick leave, the employee can take sick leave for that time. If not, the employee may not qualify for FFCRA leave unless the employee has symptoms and is seeking a diagnosis or testing. So if the employee just goes home and doesn't seek a diagnosis, the employee may not be eligible for testing, and this is in the DOL guidance. But as long as the employee has symptoms and is either seeking a diagnosis or testing, then the employee would be eligible for Families First leave. Keep in mind that the employer is likely eligible for a tax credit for the payments made to employees who are on Families First leave. So that likely makes those paid sick leave payments a wash for the employer, which is good news. And then the last question we have here is, do you have any guidance with businesses that deal with clients who may want to visit the physical office? And all of the state guidance says, try to limit as much as possible members of the public entering the workspace. If members of the public enter the workspace, whether it is, whether you're a retail company that you've got customers coming in, whether you're a professional services business that you've got clients coming in or people coming in for meetings, limit it as much as possible. Try to do as much work remotely as possible. But if you do have people coming in, you've got to follow all of this guidance in the same way that we're telling you to follow it with respect to your employees. So maintaining social distance, making sure that if people are in a meeting, they can be 6 feet apart, making sure you've got masks available for people so that they're not putting other people at risk, making sure that there's hand sanitizer and cleaning wipes and that you're disinfecting meeting rooms and congregation areas. And speaking of congregation areas, I can't say it enough, be careful about the water cooler, the coffee machine, the break rooms. You want to stagger or limit access to all of those places. Kelly, you want to wrap it up?
Yeah, I think we actually have one more question, Bill, that I'd like to ask Renee. Renee, to clarify, do all aspects of the FFCRA apply to employers, or are there different aspects that apply to smaller versus larger employers?
Well, Kelly, the Act applies to all workforces with less than 500 employees and public agencies, regardless of size. However, there is a small business exemption, and that is an exemption for employers with fewer than 50 employees. And that exemption would apply if the imposition of the Act's requirements would jeopardize the viability of the business. So in that situation, the small business should document the determination. There's no requirement that the employer send this documentation to the Department of Labor. You just need to keep that documentation so that if you are in fact audited, you'll have documentation to show that you met the requirements for the exemption.
Thanks so much, Renee. I think that does address all the questions we received from our listeners. Thank you so much for those questions. And just a thank you to Bill, Renee, and Erin for all this excellent guidance and walking us through what's really a very quickly evolving and complicated area for all businesses right now. So just want to thank our panelists and thank everyone for joining us this morning. If you do have follow-up questions or would like to talk more about any of these issues, our panelists are available to speak after this with you. And I believe our contact information is on our website as well. So again, thank you for joining us and wishing everybody a great weekend, and hopefully we will talk to many of you again very soon.
Thanks, everyone.